Good morning, everyone. Good morning, Mebatoy. Good morning, Chauke. We will begin, Mr. Mshamanyane. Advocate Batoye, remember you are still under oath. You may begin, sir.
Thank you, Madam Chair. Advocate Batohe, I think it is important that we should recap. I want to take you a little back to what was being done yesterday and what you said yesterday. I want us to recap. Remember, you dealt with your role as NDPP and your review powers. Can you repeat so that we can recap and move forward?
Do you want me to refer to a paragraph in the affidavit?
You may not, because
Can you refer me there so that I can? I'm not sure whether you want me to read out what's in the Act or whether you want me to describe something else.
I refer you to paragraphs 57 and 58. We'll go to the Act at a later stage.
Is it 50,
Just for the moment.
57 and 58?
Yes, paragraphs 57 and 58 for the moment. In recapping, so that we must tie everything together from yesterday. About your review power, start there.
So maybe we should go to the Constitution and the NPA Act that deals with this aspect. So section 1795D of the Constitution and section 22(2)C of the Act.
That's correct,
empowers a national director to review a decision of a DPP. Perhaps I can just refer to, we go to section 22(2)C so that we're clear about what exactly it says. So section 22 broadly deals with the powers and functions of the national director, and 22(2)C, 22(2)C says that in accordance with section 179 of the Constitution, the national director may review a decision to prosecute or not to prosecute.
If I may, Advocate Batoye,
Yes,
through your counsel, remember yesterday, these paragraphs that you've just referred to, as we ended yesterday, we were addressing the issue of autonomy.
Yes, I remember that.
Yes. So perhaps this is the theme that you should address. Otherwise, you'll go back to those provisions that we dealt with yesterday. I don't want to interfere with your manner of presentation, but I thought that maybe we should just capture the evidence where we left yesterday, as per my book and my notes and the paragraphs where we ended. 58 seeks to resolve the autonomy issue. When you read it together with the other paragraphs above. So I thought maybe you should just maybe address that issue of autonomy to wrap it up and then proceed.
Thank you, Madam Chair. Let me hasten to do that. Paragraph 58, Advocate Batohi, has a rider there. Let us just recap. Subject to the control and directions of the NDPP, what it means and what is autonomy. What should we understand by the autonomy that DPPs have?
Okay, so let's firstly go to the powers of the DPP. If Chapter 4, Section 20, 23, the power to institute and conduct criminal proceedings. Subsection 3 of that says that subject to the provisions of the Constitution and this Act, any director shall, subject to the control and directions of the National Director, exercise the powers referred to in subsection 1, which are set out there, institute and conduct criminal proceedings. I don't want to read out subsection 1 again. It has been read into the record. And so it says that those powers may be exercised subject to the control and directions of the National Director. So yesterday we were trying to understand what exactly this means. So, and to emphasize that these powers shall be exercised by a director in the area of jurisdiction for which he or she has been appointed. Now, if we go to paragraph of my affidavit, it's paragraph 57, well, 58 says, for present purposes, it's important to understand what the phrase subject to the control and directions of a national director mean in relation to general prosecutorial powers and functions. Firstly, we state it does not mean that an NDPP can instruct a DPP to prosecute or not to prosecute in any given criminal case. In this regard, what it does mean is that if an NDPP exercises his or her review powers of the decision to prosecute or not to prosecute, which are contemplated in Section 1795D of the Constitution, as well as Section 22(2)(c) of the NPA Act, the NDPP is acting in terms of these provisions and complying with the procedure and processes which are prescribed in the Constitution and in the NPA Act. And in those circumstances, exercising his or her review powers, he or she may overturn the decision of a DPP to prosecute or not to prosecute, and accordingly issue an instruction or direction that the prosecution must be proceeded with or charges may be withdrawn, whatever the case may be. So that's the first thing that we talk about. And then Section 58 is important because it says that if the converse were true, if
Paragraph.
Not section,
my apologies, thank you, Chair. I must remember that. I've been making this mistake too often. Paragraph 58 states, if the converse was true, that subject to the control and directions of an NDPP means that an NDPP can, outside the scope of Section 1795 and Section 22 of the NPA Act, which sets out the powers of a national director. So if a national director can, outside of the scope of those provisions, instruct a DPP or prosecutor to prosecute or not to prosecute in a criminal case, this would render nugatory or undercut the NDPP's review powers over such decisions, which the legislature did not intend. It would also be inconsistent with the constitutionally enshrined principle that DPPs are responsible for prosecutions in their respective areas of jurisdiction. We then go on to note, and this is important, particularly in the context of what one of the panel members asked yesterday about a DNDPP's powers. It is to be noted that in terms of Section 23 of the Act, any DNDPP, and we could go to that section, may exercise or perform any of the powers, duties, and functions of the National Director, which he or she has been authorized by the NDPP to exercise and perform. So in the context of the way the NPA functions, a DPP, as it says very clearly, may perform any of a National Director's functions, but relating to those that he or she has been authorized to do. And in the context of the NPA, NDPPs, Deputy National Directors, have authority over specific areas of responsibility, as I mentioned yesterday, like the DNDPP, NPS. Chair, we had made copies of the organogram, which we thought might be useful to hand in, but perhaps the evidence leader can deal with that at some point. I'm not sure, Chair, whether it will be useful to have it now or whether I can continue and we can arrange for that too. There are copies, I believe, of the organogram somewhere. But if I may continue at this point, Chair, I'm in your hands.
You may continue.
I suppose for the completeness of this record, it might be helpful,
think so.
but council will decide at
Sure.
what stage
Sure.
he wishes to hand it up.
Thank you, Chair.
But if I may, before you proceed, Madam, as I understood your affidavit, you remember yesterday there was a bit of misunderstanding with the concept subject to the control and direction of the DNDPP in paragraph 53, which seems to be extracted from the Mokoro report.
That's correct.
And as I understand your affidavit later, the subsequent paragraphs and the very paragraph that you have just read, which is paragraph 58, this paragraph seeks to very comprehensively, to me, to be addressing that very issue that you addressed yesterday.
That is what I'm doing today, Chairperson,
Yes.
because I realized there was some lack of clarity in that regard.
Yes. So paragraph 58, Council, seems to clear that issue that we spoke about yesterday. And as you proceed, I suppose that settles our mind as regards the issue of autonomy, the control and direction that we spoke about yesterday, as per the Mokoro report, that we said, because we don't have the entire report in front of us and cannot read that paragraph in its proper context, we need clarity. And as we read later, it then emerges from 58 that the answer is in that paragraph that you've just read.
Thank you, Chair. And it's important to note that the point is that the DNDPPs actually have the same powers and functions of a national director, but in respect of the area that they've been authorized to perform. And the DNDPP NPS would then have those powers in respect of the National Prosecution Service. Thank you, Chair.
Maybe just before you proceed further, can you just advise as to whether the NDPP has the power to review the decision of another NDPP, like the predecessor in particular?
There is nothing specific in the Act that talks to that issue. But I would think that given let me look at the powers of the NDPP as it's set out before I respond more in a better informed way. If we look at the powers of the National Director, which is in Section 22, the National Director as the head of a prosecution shall have the authority over exercising of all the powers, performance of duties. Sorry, I'm just reading this out. Paragraph 2C of Section 22 states that in accordance with Section 179 of the Constitution, the National Director, C, may review a decision to prosecute or not to prosecute. In my view, that gives the National Director the power to review any decision to prosecute or not to prosecute.
I beg your pardon?
Chairperson, I'm saying that paragraph 2 of Section 22 states that in accordance with Section 179 of the Constitution, the National Director may review a decision to prosecute or not to prosecute. So if we stop there, the National Director can review any decision to prosecute or not to prosecute taken at any time by any person, and that would include a previous National Director.
I'm not sure whether you understand the question by my sister, or am I missing something, my sister?
No, you're not missing.
I think, please repeat the question. Advocate Batoi does not seem to understand your question. The question is confined to the powers of the DPP of a particular area, whether he can exercise review powers of another DPP. Am I correct? Am I correct?
Another NDPP, and I said specifically like a predecessor.
That was my understanding, Chairperson.
Or NDPP.
Yes, that was my understanding. Whether an NDPP can review a decision of a previous NDPP. And that is why I said, given that 2C of the NPA Act states that the National Director may review a decision to prosecute or not to prosecute. My understanding of that will be that it gives a National Director the power to review any such decision, whether it's made by a prosecutor, a Deputy Director of Public Prosecutions, a DPP, or even a previous National Director.
In short, your answer is she or he may.
That is correct, Chairperson.
And that is your understanding in the face of a clear provision in the NPA Act. To review the decisions of the
to review any decision to prosecute or not to prosecute. And I emphasize any decision. In fact, any is not in the Act, but the Act says may review a decision to prosecute or not to prosecute. And my interpretation of that is that it is any decision to prosecute or not to prosecute.
Chair, I think I've made my point. It's about in the face of, or even, but that's fine. Let me proceed.
Chairperson, I'm sorry if there's a lack of clarity. I'd like to be given the opportunity to clarify because it seems like there's still a lack of understanding to the extent that I can.
Through you, Chair. I understand your interpretation. And I think you correctly say, according to my understanding, the succeeding provisions give me the power. That's where you believe the NDPP gets the power to review the decisions of other NDPPs, and in this case, like I said, the predecessor.
Chairperson, if I may clarify, in my view, it's not, it states in the Act that the National Director may review a decision to prosecute or not to prosecute. And given that it does not exclude a National Director, that it gives a National Director that power.
Let's look at the practical scenario because I'm getting confused. Looking at the number of former NDPPs and those who acted. Let's look at the situation of NDP or acting NDPP Nkasana. Let us assume that he had made certain decisions. Will the subsequent NDPP have the power to review the decision of the former, in this case of Mr. Nkasana?
In my view, Chairperson, that person would, the new NDPP would have that power to review the decision of a previous NDPP. It doesn't matter who it is, but that power, the current NDPP would have that power.
In terms of the Act and the policy directions, could you just take me to the provision that relates to that?
Chairperson, in terms of the Act, I have mentioned Section 22, Section 22(2)(c), which says that in accordance with Section 179 of the Constitution, the National Director may review a decision to prosecute or not to prosecute. So in terms of that section, I say that a National Director can review any decision to prosecute or not to prosecute, whether it's taken by a previous National Director or any other member of the NPA. I should have a copy of the Constitution in front. I used your copy yesterday, Chairperson. You should make
Yes, my challenge is if this is the case, it essentially means that you are reviewing your own decision because you are in the same office. It is the office, not the name of the incumbent. In this event, Mr. Nkasana was in this very office, your office. How then do you review your own decision? Because it really means that you have taken a decision 5 years ago as the National Director of Public Prosecution. 2 years later, you come back and review your own decision, the decision of that office. How possible is that?
Chairperson, I'm thinking about this, and
Let me give you an example. I'm not sure whether this example is opposite. A judge in the High Court makes a decision. That judge cannot come back later and reconsider her or her own decision because he or she is functus officio. The same principle should apply in relation to your office. Not so.
Chairperson, I need to think about that, because the position of a DPP, once you take a decision as a DPP, you can always, the same DPP, you can if you get information, you can actually review that decision in a sense of relook at the evidence, decide whether that decision was the correct one, and you can change your decision as a DPP. You may decide not to prosecute, and then there may be other factors that are taken into account, and then you rethink that and you say, I will actually prosecute this matter. So I think there's a difference in terms of whether the functus officio principle, how it applies with regard to prosecutors and a DPP. And I think we need to look at this carefully, because in my view, DPPs are required in terms of our policy to reconsider evidence, to reconsider matters all the time. So it happens that we would actually prosecute and then for various reasons decide not to prosecute. The converse may happen. So I think we need to think very carefully about whether the functus officio principle applies to a DPP, because in my view, it cannot, because a DPP constantly reviews his or her own decisions, whether to prosecute or not, and changes them depending on what the information and evidence is before them. So I think we need to carefully think through this. For current purposes, in my view, it does not apply to a DPP who's made a decision. And then if we take it, and I think we do need to look at this and carefully unpack the legal implications. But in my view, as I sit here now, without really interrogating this properly and doing some kind of legal research into it, that the fact that DPPs constantly are required to rethink and revise and review their own decisions on the basis of other information, that principle does not apply to prosecutors.
Yes, I know my sister wants to the principle of finality and legality. If you have, say, for instance, 10 NDPP, one coming after the other within maybe, say, 5 years, the first one decides, 2 years later, the second one comes and upsets the decision of the former. The third one comes and upsets the decision of the second. Will that not impact adversely the principle of finality and legality, and also the interests of justice, and the very right of the victims and the accused people? I do not have clear. I would like you to reflect very carefully on this aspect, because the Act, that provision that you referred us to, seems not to be a model of clarity. We are not interpreting the legislation here, but given the answers you gave, it makes it very difficult to understand. And if that provision means what you say, then I'll have difficulties with that. So that's why I'm saying, perhaps, Council, we can defer these questions so that Council, Advocate Batoyi, can reflect properly on the provision and how she understands the provision. Then we can revisit that later.
Indeed, Madam Chair.
Because I think all of us need clarification.
Yes, I think she should reflect on that.
From her,
yes,
and subject to the advice by Council on the extreme right, so that we can make progress and then revisit that at a later stage when she has properly applied her mind to these questions. And perhaps my sister can ask further questions, if you may, then she can also reflect on that.
Thank you, Chair. Thank you, Advocate Batoyi. Further to the question that has been raised, is the Act seems to give the NDPP the right to review the decision of the DPPs and whether to prosecute or not. Now, our issue is whether an NDPP can come in after and review a decision that was taken by the previous NDPP. Does the Act give, because once you get into that position, you assume all the powers. You are a successor in title. The decisions that were taken by the previous NDPP are your decisions now. So, and that's where the issue of reviewing your own decision comes in. Does the Act entitle you to review another NDPP's or the previous NDPP's position? Wouldn't that result in some absurdity where, because the previous NDPP prosecuted someone that I like, when I come in, I reverse that? Wouldn't that cause a situation like that? Thank you, Chair.
Is one you can just list those questions in fairness to you so that you can reflect, and then we will revisit that. Ramachaka would like to also ask a question.
Yeah, as you reflect, I think it will help a lot to look at the constitutional provision that empowers the NDPP to review. Their reviewing powers, remember that the NPA is actually drawn on the basis or on the instruction of the Constitution. So to go to the enabling provision in the Constitution, I think helps a lot, because the NPA can never ever trump the Constitution. And if you are to look at that section 179 of the Constitution, and in particular,
If
subsection,
the evidence leader can please give me a copy of the Constitution. I don't have a copy of it in front of me.
right,
I think you can donate that copy to council.
We have a lot of these in my office, Chairperson. I should have brought one of them.
yes, and in particular, subsection 5.
Mhm.
Are you there?
I am.
Okay. It reads, the National Director of Public Prosecutions, let me see, ABC, the reviewing powers are found in subsection 5D. Yeah? It says the National Director of Public Prosecutions may review a decision to prosecute or not to prosecute after consulting relevant Director of Public Prosecution and after taking representations within a period specified by the National Director of Public Prosecutions from the following. Those just, they don't matter much. What matters much to the question that I have posed, the question that you're going to think about and maybe even seek counsel to, is where the Constitution says, after consulting the relevant Director of Public Prosecutions. And that's all. And this in itself, I think will get attention during the engagement with council. Thank you.
Chairperson, if I may make one point now, and that is there's two provisions in the Constitution and in the NPA Act that deals with a national director, let's say loosely, getting involved in a prosecution process. We're not looking at section C of the Constitution, that's 1795C, which says the National Director of Public Prosecutions may intervene in a prosecution process when policy directives are not complied with. That we must not forget that that is also an important power of the National Director, to intervene when policy directives are not complied with. So if there's any prosecution process where the National Director, any National Director, is of the view that policy directives had not been observed in a process, in my view, and we can still go and get the necessary legal opinions, this would also permit a national director to intervene in a prosecution process under those circumstances. In addition to paragraph D, which gives a very specific review power to the national director. And we must distinguish between the power of a national director to intervene in terms of paragraph 5C of 179 of the Constitution and paragraph D, which is to review. So I think these are two important aspects. And in my view, even the intervention, if a previous national director or any member of the prosecuting authority, it appears, has not complied with policy directives, a national director, provided that condition is met, a national director may intervene in a prosecution process.
Post ex facto, meaning you can intervene after the event,
That is correct, Chairperson.
even if it's 10 years later?
If the interests of justice demand that because policy directives were not complied with, that it should be done, as I sit here today, I would think that then the national director should be able to look into what happened to assess whether there was something that untoward happened because policy directives were not complied with.
So I would like you to properly reflect on this, because if you look at the chilling effect of that kind of a conduct, if after several years a new incumbent upsets what happened many years ago, that will be nonsensical and will affect the interests of so many people. It will affect the interest of the victims, of the accused people, and generally the administration of justice in terms of finalizing matters timelessly. Because when matters run for many years, that has a chilling effect on so many people. So I'm just saying to you, reflect upon it properly. We may be wrong, but I'd like you to take a step back and reflect on these issues that we are grappling with.
Chairperson, I will certainly do that, but to comment on your comment about a chilling effect, my view is that it could have the converse chilling effect if there was a grave miscarriage of justice, and if 10 years later a national director is not able to correct it. In my view, that can also have a chilling effect for victims, for the interests of justice. So I think we need to, as you say, carefully apply our minds to it. But I think it could cut both ways. Thank you, Chairperson.
Thank you. Advocate Mutlamana.
Thank you, Madam Chair. Advocate Patohi, let me then direct you to paragraph 61 on page 28 of your affidavit. You'll recall that yesterday you indicated that the prosecution policy, directives, the code of conduct are in place, which have been framed by the NDPP in consultation with the relevant authority, executive authority. Can you explain the extent to which the prosecution policy and the code of conduct bind prosecutors. You may start with the prosecution policy.
The prosecution policy, the policy directives, and the code of conduct, which have all been issued in terms of Section 22 and 22(6) of the NPA Act, must be observed in the prosecution process. So this means that every prosecutor in the country is obliged and must observe these important instruments. So, for example, as I continue, subjecting the prosecutorial powers of a DPP and prosecutors to the prosecution policy would, amongst others, be that such a DPP and prosecutors are required to take into consideration all the factors that are delineated in the prosecution policy that must be taken into account when deciding whether to institute a prosecution or not. And I do know that somewhere in my affidavit, I set out what these factors are. I'm not sure if the evidence leader can guide me in terms of what paragraph that is, but it sets out these factors that a prosecutor should take into account when making a decision to prosecute or not. It also means adhering to prosecutorial practices, norms and standards, professional and ethical conduct as delineated in the policy directives and the code of conduct. And as I said, they must be complied with by all members of the NPA. There is a paragraph, it would be good to link it now to where these are set out in terms of the factors to be taken into account. But perhaps we'll come to it later. I just don't have it on hand at the moment.
We'll deal with it later on. But for the moment, let's go to paragraph 66.
Perhaps, sorry, I think paragraph 78 might deal with the prosecution policy prescribes the various factors which must be considered by a member of the NPA, including a DPP, when deciding to prosecute or not to prosecute. In essence, a DPP, as with all prosecutorial members of the NPA, must have regard to the contents of the case docket, that is, the prima facie evidence and statements contained in a docket, as well as any version proffered by the accused in what is called a warning statement or a confession or other statement made by the accused. The DPP or prosecutor must evaluate such evidence, taking into account relevant factors, including how strong the case is for the state, whether the evidence is admissible, whether the state witnesses are credible, whether the evidence is reliable, whether the evidence is available, and how strong the case is for the accused or the defense.
Yes, that is dealt with when you are dealing with the responsibilities, powers of a Section 6 DPP.
That is
We
correct.
will revisit it.
Yeah,
for
okay,
the-
we can revisit, but it
Yeah, we'll
links
revisit.
to
Yes,
this point.
it relates to that.
Sure.
Now let us get to paragraph 67, where you're dealing with Section 23, subparagraph B. In fact, you have already read into the record Section 23, A and B, not so. You've already read it into
I
the
believe
record.
so.
Yes. Now, explain how, as a national director, you will exclude expressly in writing or otherwise certain offenses where a where a Director of Public Prosecutions, a DPP, would not exercise. In terms of paragraph B, it says any offenses which have not been expressly excluded from his or her jurisdiction. We know that the DPP has a power and duty to institute criminal proceedings within his area of jurisdiction, unless they've been expressly excluded from his or her jurisdiction.
So, as I mentioned in paragraph 67, this would happen where, for example, the IDAC is investigating. That's the Investigating Directorate Against Corruption. And they have jurisdiction over cases across South Africa. So that would be a case where the DPP would not exercise jurisdiction in his or her area of jurisdiction, but the investigating director would exercise jurisdiction. But the NPA Act does require, and I don't have the section in front of me now, that the investigating director, when doing this, is required to consult with the DPP of the jurisdiction where the case will be heard.
Yes. Sorry to interrupt you, Advocate Batohi, but can you explain what IDAC is? What is IDAC for the benefit of those who may not understand what IDAC is?
Sure. I just mentioned it's the Investigating Directorate Against Corruption. It is an entity that is within the National Prosecuting Authority, which was established by an amendment to the NPA Act that was effected last year, promulgated last year. I think it was in August of 2024 when the Investigating Directorate Against Corruption was formed. It is part of the National Prosecuting Authority. And the investigating director is the head of the IDAC, as it is called, Investigating Directorate Against Corruption. So the ID, that is the investigating director, is on the same level as a DPP, is in fact, the rank level is the same as a DPP. And so when the IDAC, the ID, exercises jurisdiction in terms of prosecuting cases in various parts of the country, those cases then will not be, it will be a case that the DPP in that jurisdiction will in fact not be exercising jurisdiction over. So,
yeah.
And am I correct that the matter we assist with does not fall within that category?
that is correct, Chairperson. It does not. Even the other example that I have, which is Special Director of Public Prosecutions, if they do have prosecution powers, like was the case in the past, it could mean that the DPP will not exercise jurisdiction of a case where the SDPP has decided. But this case does not, that scenario doesn't apply in this case.
And if you may, I beg your pardon, sir, if you may, Counsel, not everybody understands the acronyms that you refer to. As you testify, try to obviate the use of acronyms. Or if you do, give us the full name and constantly refer to that if you choose then later to refer to an acronym.
Certainly, Chairperson. The SDPP in this case is a Special Director of Public Prosecutions. I'll leave it at that. But as I said, those scenarios don't apply in the current case or matter that the inquiry is looking into.
Thank you, Madam Chair. The issue of IDAC investigators and IDAC itself to be brought into the current situation we're dealing with has been done for purposes of distinguishing and for purpose of clarity as to the difference, if any, between an ID and a DPP. Am I correct?
That's correct, Chairperson.
Now, let's proceed to the next important topic, which appears on page 30 of your affidavit, where you are dealing with directors of public prosecutions. You have already indicated what they are, who they are, and where they fit in the structure, where DPPs fit in the structure of the NPA. Now, in paragraph 68, you are saying that DPPs are appointed by the president. Is that correct?
That is correct.
In terms of section 13 of the NPA Act.
That is correct.
If they are appointed by the president, does that mean they are answerable to the president?
No, it does not mean that.
What does it mean?
It means that the president appoints them. They are not answerable to the president, because in terms of the Constitution and the NPA Act, the NPA's independence insofar as its functional independence, operational independence is guaranteed. So that means that a member of the executive cannot interfere in the work of the NPA insofar as its prosecutorial functions are concerned. But of course, the NPA requires the support and of the executive in terms of the budget, and there is a reporting line in the Act to the minister. But apart from that very limited scope, the president or a minister cannot interfere in the work of the prosecutorial work of the NPA.
Thank you. Let's go to the next paragraph, paragraph 69.
That paragraph answers the question that we have just asked her, and she has answered it. If you look at the last line, maybe you can go to 70.
I just wanted to
Perhaps if I may, the important part of 69 is just to emphasize again that DPPs have original jurisdiction and responsibility for criminal prosecutions falling within their area of jurisdiction in which they've been appointed.
Yes, thank you, Advocate Batohi. I wanted you to deal with that, tie it with what is stated in paragraph 70 as far as their powers of the DPPs are concerned. Now,
so as sorry.
Yeah, maybe before you proceed, it brings us to the issue of a DPP, a Section 6 DPP of one jurisdiction exercising powers or functions in another jurisdiction. If you can explain that in full, the circumstances under which a Section 6 DPP of one jurisdiction can exercise his or her functions in another jurisdiction.
So as it's clear from the Act, the Constitution and the Act, a Section 6 DPP has jurisdiction for all matters falling within his or her area of jurisdiction in which they have been appointed. In fact, the Nkabinde Enquiry found that there is not a circumstance, and that is, in fact, if one looks at the Act, the Constitution, it does not permit that a Section 6 DPP oversee prosecutions taking place in the area of jurisdiction of another. I pause here to add that there is one instance where I mentioned it yesterday, the centralization of cases, where you have different offenses committed in different parts of the country. Then it would be the situation where once the two DPPs apply to the national director to centralize these matters in one of those jurisdictions, in that instance, of course, the DPP, in respect of the jurisdiction where the matter is now going to be heard, there will be a case from another jurisdiction being heard in that jurisdiction. But that is by agreement and ultimately the authority and approval of the national director to centralize these matters into one area for the sake of convenience, because there are offenses in different parts of the country. Section 70, then, we do explain further that
Paragraph 7.
my apologies, Chairperson. Paragraph 70, I state that the relevant part there is there's no provision in the NPA Act that deals with a scenario where a DPP from one jurisdiction can exercise powers in the area of another DPP. So it's not in the Act, it's not in the policy, it's not in the directives. A DPP cannot take decisions in respect of another DPP's area of jurisdiction. In other words, DPP of one jurisdiction cannot exercise jurisdiction over prosecutions of another. It means that a DPP of one area cannot control, direct, run with, supervise, and coordinate a prosecution falling within the jurisdiction. There's a slight editorial typo there, but falling within the area of another DPP's jurisdiction. I think we'll get there, but I think Section 30 of the NPA Act deals specifically with the powers of the DPP. I'm not sure if that's covered, whether we specifically went to Section 30, but I think that's an important section that we should highlight. If I've got that
Yeah,
correct. I'm not
Advocate
sure.
Patohe, that you dealt with yesterday when we were dealing with centralization.
That is correct.
But I want you to go to section.
Sorry, Advocate Nkabinde. In as much as there is no provision in the NPA Act that deals with a scenario where that you have explained, is there a provision in the Act that prohibits that action?
So you would respect which action is the...
What you describe at paragraph 70, where you say a Section 6 DPP cannot exercise his powers in
another.
Yes. Section 6 DPP's jurisdiction. Yes. You say there is no provision in the NPA Act that deals with that scenario. My question is there a provision that prohibits that action?
Chairperson, for clarification, and well, let me answer. Firstly, the powers of a DPP are set out in Section 24 of the Act, and that makes it explicit that a DPP, subject to the provisions of Section 179 and other relevant sections of the Constitution, the NPA Act, or any other law, a director referred to in Section 13 has, in respect of the area, and I emphasize, in respect of the area for which he or she has been appointed, the power to institute and conduct criminal proceedings, carry out functions, and then to supervise, direct, coordinate the work and activities within all of the powers that are set out in subparagraph A to D of Section 24(1) must be in respect of the area for which a director has been appointed. And that is important. It means you cannot, you are required to exercise it in your area of jurisdiction. So that is explicit, and that is why, in addition, well, I shouldn't say in addition, but the paragraph 70, the part in paragraph 70 that says there is no provision in the NPA Act specifically refers to the sentence before that, which is an NDPP cannot ask a DPP from one area to evaluate the work of another DPP in another area, because the DPPs are appointed and exercise powers in their particular area of jurisdiction. And in respect of that evaluation, there is no provision in the NPA Act policy, prosecution policy, or directives dealing with that scenario. But to answer specifically your question, Section 24(1) will address that.
Thank you, Advocate Patohi.
Yes. I don't see anything that deals with exclusivity in Section 24. Would that have been the drafters' deliberate exclusion of exclusivity to create room for maneuver, or to create an escape clause? Because it only says you can only exercise your powers in your area of jurisdiction, but it doesn't take it any further. Or are you then extending it by interpretation or by a rule of practice?
I'm not, the Act specifically states that a director shall do all of the, exercise all of the powers set out in A to D in respect of the area for which he or she has been appointed. And that is clear.
Were you reading in which section?
24(1) of the NPA Act.
Chair, unless if maybe my wording here is wrong, I don't see shall, but it's fine.
Oh, I apologize. Yes,
I will live with it. Okay.
Yeah, no, there's no, I was just paraphrasing at the time. I was not reading at the time. Maybe I will, if the chairperson wants me to read out the precise wording of the Act.
Not necessarily.
Thank you, Chair. Thank you, Chair.
My understanding of my sister's question is whether the legislator intended to expressly exclude that possibility. Yes. You see, the point is, let's assume, I'm just thinking aloud, let us assume that all the prosecutors in KZN are conflicted and cannot handle a particular case, and a need arises for the matter to be finalized in KZN. Will any prosecutor from Gauteng be excluded from being sent to KZN
No,
to
Chairperson.
perform a prosecutorial function there?
No, Chairperson, but there's a very specific difference between the jurisdiction that a DPP exercises in terms of Section 24 and a prosecutor who may be required to perform a function in another jurisdiction. In that circumstance is actually catered for, and by practice, if prosecutors in KZN are in fact the scenario that you sketch, we could then, by agreement of the DPPs, take prosecutors from anywhere in the country to go to KZN to prosecute the matter there, but they would then act under the jurisdiction of the KZN DPP, and that's an important distinction. And they would then also get the relevant delegation, either from the DPP in KZN to prosecute in KZN, or potentially also from the National Director.
In other words, the Act does not specifically exclude that kind of a possibility in
But
the event it arises.
it does not exclude what I am testifying about now, but it excludes a DPP exercising jurisdiction over a case in another jurisdiction.
No, that is clear.
Yes, okay.
We are now dealing with a different scenario.
Then that's
If
correct.
circumstances arise where people in KZN, prosecutors in KZN are conflicted in a particular matter, and a situation that necessitates someone from a different province to go in and execute that prosecutorial function in another. I think this is what my sister was trying to ask you about, the exclusivity part of the legislation, whether there's any provision in the legislation that excludes that possibility.
Chairperson, my understanding of what your sister was asking was about a DPP. And my understanding that the second scenario, you've now indicated that is settled. The second scenario that you have now put before me is the scenario where KZN prosecutors are conflicted and you get prosecutors from elsewhere going to that province to prosecute. That's the second scenario is permissible, but there are certain things that must be done. One is the DPPs must agree and consent to this. Secondly, the prosecutors that actually go to KZN, because they're coming from another division, they must get a delegation from the DPP of KZN that allows them to prosecute in KZN. And there's also the possibility of the National Director giving delegation to prosecutors to prosecute in areas outside of their own, of the division that they are stationed in.
Yes, I know that you are using the words prosecutor and DPPs, but in the simple language, they are all prosecutors.
Chairperson, my view is that there is an important distinction between a DPP's powers and a prosecutor, what a prosecutor can do. The DPP's powers are restricted to a particular area of jurisdiction in terms of the Act. The same does not apply to prosecutors.
Understand, Madam. Let's try to move forward. My question relates, we know that we are talking about Mr. Chauke here. Let us not talk about this broader picture. It doesn't assist us. The question arises, can Mr. Chauke leave South Gauteng area of his jurisdiction and go to KZN if circumstances arises to go and function as a prosecutor there or as a DPP there?
That is not permitted, Chairperson. As a DPP, he cannot exercise he cannot exercise jurisdiction over a case that emanates from another division.
Now, in the instance where the DPP in a specific area is conflicted, unless if we want to say DPPs may never be conflicted. But if a DPP is conflicted, how do you then deal with that scenario?
So that scenario, Chairperson, and I'm just thinking through what you said about a prosecutor moving to another division. Let's assume indeed the DPP of Gauteng needs to go to KZN to prosecute a matter. There's two things that should happen. One is the DPP, if it's possible, and I'm not even sure that it's legally possible, he should get a delegated authority from the DPP in that division. But if the DPP, him or herself, is conflicted, which is the scenario that the panel member is putting forward now, then in that instance, the national director should give that DPP, if it's permitted, because I haven't thought this, I don't know that it's happened that a DPP has gone to another division to prosecute a case. It may have happened. Then the national director should issue a delegation to that DPP to prosecute in the jurisdiction, in another jurisdiction. So those delegated powers to prosecute in another jurisdiction are critical for any person coming, any prosecutor coming from outside of that jurisdiction to prosecute a case in the jurisdiction where the case is being held.
Advocate Motlamanyane, I know that we are dealing with the legislative framework and dealing with the powers of the DPPs, etc. But when we come to the crux of the case, these issues might arise. Therefore, I propose that we move forward.
Indeed, Madam Chair. Now, in trying to elucidate what you were explaining to the panel, there is what is called a receiving DPP and a requesting DPP. Can you explain that scenario?
Take me to the
It's not in the a DPP of another district, of another jurisdiction. Are there instances when such DPP can make a request?
Yes, that is correct. A DPP of one division can request assistance from another DPP in another division for prosecutors to come and prosecute in their division. This is a scenario that I did deal with earlier on. In the event that that happens, the DPP of the receiving jurisdiction must issue delegation to those prosecutors to prosecute in the receiving DPP's area of jurisdiction.
Yeah, we will later deal specifically with Advocate Chauke's issue.
Mhm.
But it would appear to me it is an opportune moment. I'm reminded that it may be an opportune moment to adjourn for tea recess.
Totally forgotten that there's something like tea that we must have and stretch our legs. We ought to have adjourned at 11:15, but we started late. We'll take a tea break now until 12 o'clock. This means that we'll have lunch a little bit later than 1:30, as we did yesterday. Let's adjourn for tea until 12 o'clock. We adjourn.
with the Minister and the National Director, may, subject to Section 6.2, appoint a Director of Public Prosecutions in respect of an office, my emphasis, in respect of an office of the Prosecuting Authority established by Section 6.1. So we then go to Section 6.1 of the NPA Act. Section 6.1 of the NPA Act refers to offices of prosecuting authority at seats of high courts. Section 6.1 states, the cabinet member responsible for the administration of justice, A, must establish an office for the prosecuting authority at the seat of each division of the High Court, provided for in Section 6, in terms of Section 6.1, and that is relevant for present purposes. And then if you look at Section 6.2, an office established by this section shall consist of the head of the office, who shall either be a director or deputy director, and who shall control the office. It shall consist of deputy directors, of prosecutors, etc. So if we then, it's clear from these two sections that a DPP is appointed to an office established in terms of Section 6.1. And then if we go to Section 23A, it states that subject to the provisions of the Constitution and this Act, any director shall, and I want to emphasize the use of the word shall in this section, subject to the control and directions of the National Director, exercise the powers referred to in subsection 1, and I'm not going to read those powers out now, in respect of A, the area of jurisdiction for which he or she has been appointed. And I want to indicate that when directors of public prosecutions are appointed, they are appointed to exercise jurisdiction. They're appointed to an office, and they are, in terms of Section 23, which I've just read, they exercise jurisdiction over, let me get the language again, the area of jurisdiction for which he or she has been appointed. The president appoints directors of public prosecutions to a particular office. And I have obtained a letter of appointment that is sent to a DPP, as well as a presidential minute that is signed by the president. We do have copies, Chairperson. Would the panel like copies of these now? I'm not sure how we would deal with this. I do have them in front of me.
Through your counsel, for
Through-
the
thank you.
evidence leader at
Coun-
the time he considers appropriate.
May I proceed, Counsel?
Yeah,
or-
you may proceed.
Thank you.
May I get copies? I
Um,
do not have a copy with me.
The copies behind you, we'll just hand that to you now.
With your permission, Madam Chair.
We do have copies available.
Oh, we do have copies. My apologies. I deem it appropriate that it be handed up. With your permission, Madam Chair.
Yes, sir. And just make sure that whatever you're handing in, just label it as an annexure or just something. And if I may recap, these documents, what are they?
The first one, Chairperson, is, well, the first one is the President's minute which relates to the appointment of the DPP, Advocate Zungu, as she then was, as the Director of Public Prosecutions in KwaZulu-Natal. It's an example of a presidential minute that is signed when the president appoints a Director of Public Prosecutions. The second document is a document signed by the Minister of Justice at the time, Minister Lamola, to Advocate Zungu, informing her of her appointment as the Director of Public Prosecutions, KwaZulu-Natal. The first one is the President's Minute. It's headed President's Minute. If I may read into the record, Chairperson.
Before you do that,
Sorry.
Advocate Batohi, pardon me, Madam Chair,
When you look at the sequence of events, you probably look at the dates. So the first one is the presidential, I beg your pardon, is the ministerial appointment, 25 October 2019, and the presidential minutes is 11 November, okay, I beg your pardon,
both
11th October
The minute is the first one.
2019.
Minute comes first.
So the minute comes first.
and I ask Madam Chair that they be marked as exhibits 1 and 2 respectively. The first one being the President's Minute.
The documents are marked accordingly.
Thank you, Madam Chair. You may proceed.
Thank you, Chairperson. I'll read into the record the Exhibit 1. It's President's Minute number 432. I hereby under Section 13(1)(a), read with Section 6(2) and 9(1) of the National Prosecuting Authority Act 1998, in brackets Acts 32 of 1998, and after consultation with the Minister of Justice and Correctional Services and the National Director of Public Prosecutions, appoint Advocate Elaine Zungu as Director of Public Prosecutions of the KwaZulu-Natal Division of the High Court, Pietermaritzburg, with effect from 1 November 2019. Given under my hand at Johannesburg on 11 day of October 2019. It's signed by the President, and below the President's signature, the Minister of Cabinet. The second exhibit, Chairperson, is the letter from the Minister Lamola, dated 25 October 2019. Should I read out the contents, Chairperson, or is it not necessary? But the Minister is communicating the decision of the President to appoint Advocate Zungu as the Director of Public Prosecutions, KwaZulu-Natal Division of the High Court, Pietermaritzburg.
For completeness purposes, just read the whole content.
I
of the
will.
letter.
It's addressed, this minute is addressed to Advocate E. Zungu. Dear Advocate Zungu, appointment as Director of Public Prosecutions, the subject line, appointment as Director of Public Prosecutions, KwaZulu-Natal Division of the High Court, Pietermaritzburg. It gives me pleasure to communicate to you the decision of the President to appoint you as the Director of Public Prosecutions effective from 1 November 2019. Please find attached the approved Presidential Minute 432, I repeat that, Presidential Minute 432, in terms of Section 13(1)(a), read with Section 6(2) and 9(1) of the National Prosecuting Authority Act 1998, in brackets Act 32 of 1998, dated 11 October 2019. I take the opportunity to wish you well on your appointment. It is kind regards signed by Minister R.O. Lamola, Minister of Justice and Correctional Services, on 25 October 2019. Chairperson,
I suppose these exhibits are handed up merely to endorse the statement at paragraph 68, the first sentence regarding the appointment of the DPPs. Is there any other reason why we have those examples?
Yes, the fact that, Chairperson, they are appointed in a particular division of the High Court. In this instance, Exhibit 1 as Director of Public Prosecutions, KwaZulu-Natal Division of the High Court, Pietermaritzburg. And Exhibit 2, the subject line of the Minister states, appointment as Director of Public Prosecutions, KwaZulu-Natal Division of the High Court, Pietermaritzburg. And the point being, Chairperson, that the DPPs are appointed by the President to exercise jurisdiction in the air to an office and shall exercise jurisdiction in the division to which they have been appointed. Thank you, Chairperson.
Council, please proceed. Please proceed, Council.
Thank you, Madam Chair. Now, I want you to recap on this aspect here, where let's take this example. There were prosecutors from Gauteng who were tasked to do duty in KZN.
Council, may I please allow me to interpose? That's one of the crux of the issues that we have to deal with.
Yes, Madam.
Just
Chair.
leave that for later, please, because it's going to attract a lot of questions from us. I don't want to interrupt with your way of presenting, but you were dealing with the role in terms of the affidavit. And as we progress, it seems as if we are jumping into another topic. May I request, with respect to you, that we leave it for later?
Maybe I misunderstood your line of dealing with it. I thought you wanted us to jump into it immediately. Maybe I misunderstood.
Yes, I think
Yeah.
you can tell us if you are doing that, because if you want to jump everything else and zoom into the crux, that is going to be under the rubric
Under where it starts from 58.
I beg your pardon, just bear with me. You see, we were dealing with Directors of Public Prosecutions, their roles, etc. We are not yet into the meat of the issues before us, and I suggest that don't exhaust it now, unless if you really want to jump into the issues.
Not exactly. I was under the impression that Madam Chair would want us to just get into the issue, the meat of the issue, but maybe I misunderstood you. My apologies.
I know that we were at paragraph 68, 69. She may want to deal with that. I think if you want to jump all those paragraphs regarding the Directors of Public Prosecutions, you may tell us so.
Madam Chair, I was not intending to jump them. Allow me to proceed from where we ended.
You may do so. And obviously, Council, you need not go into case law and too much into Mokoro's report.
Don't have to.
Mokoro's report does not bind us.
Indeed, I agree, it doesn't.
Don't go into jurisprudence. let's deal with those aspects that we might just want clarity from, because Advocate Batoi is better placed to inform us as regards the facts. And as you gather the facts, try to focus on those areas that will assist us.
Thank you, Madam Chair. Advocate Batohe, we have dealt with, you've read into the record, Section 24(1) of the Act, of the NPA Act. We don't necessarily have to repeat that. Now, go to paragraph 76. And explain the powers of a DPP insofar as any appeal is concerned, which is of course contained in the Act.
Paragraph 24.
Not paragraph 24. We dealt with section 24, if I may.
That's correct.
It has been read into the record, and I'm saying it's not necessary to go back to that.
Yes, just for this purpose of the record, paragraph 73 deals with it, and paragraph 74. Well, right from paragraph 70.
Yes, that's been
deals
dealt
with it.
with. Let's not go back to it. I was directing your attention to paragraph 76, and you can read that and explain it in conjunction with what is contained in section 22. No, I beg your pardon, 24, subsection 8. Subsection 8.
Subsection reads, the powers director under section 21 shall include the authority to prosecute in any court any appeal arising from criminal proceedings. And if you read that with section 21, again, it must be with regard to a case that is in respect of the area of jurisdiction for which he or she has been appointed. So it is one of the functions of a DPP. Section 24 sets out a number of them. And in paragraph 76, we explain that a power to prosecute an appeal is also a power given to a DPP if read with section 20 in respect of cases emanating from his or her area of jurisdiction.
Now, you have dealt with the prosecution policy. What are the duties of a prosecutor or a DPP in terms of the prosecution policy? Now, we will not spend much time dealing with paragraphs 79, 80, 81, 82, and 83, including 84, 85 as well, 86, will not deal with it. Go to page 37 and look at the NPA's role in prosecuting crime, just in a nutshell, because we have already referred to in extenso refer to the role of the NPA, but just do it in a nutshell briefly so that we can move forward.
As we've mentioned, prosecutors have a constitutional mandate to prosecute crime. And as per paragraph 89, the importance of the state's duty to prosecute is implicit in section 1792 of the Constitution, which is set out in that paragraph. And so paragraph 90, it flows from this section of the Constitution that prosecution of crime is a matter of fundamental importance to the state. At paragraph 91, the Constitutional Court has recently affirmed, and we refer to the case of Corruption Watch, that the NPA is at the center of any well-functioning democracy. At page 92, we again,
paragraph 92.
Paragraph 92, we again emphasize that prosecutors serve as gatekeepers of the system. And we present cases in court. This is the role of the prosecutors. We represent the interests of society throughout these proceedings. And a quotation there, and it is important because it is a quotation, but this is actually very important for prosecutors. It's what we do. The role of a prosecutor, which I mentioned in my opening remarks, comes with great responsibility, as prosecutors are vested with the power to charge the accused, to try accused. We must seek justice, do justice, protect the innocent, and charge the guilty. And at page 95, at paragraph 95.
Yeah, just in paragraph 95, you're dealing with the integrity of the system, which is
That's
largely
correct.
dependent on the integrity of the prosecutor. Can you explain?
It brings the entire system into disrepute. Integrity of a system is not something that can be assessed as if the system sits on its own somewhere. The integrity of a system is dependent on the integrity of the people who work within a system. And so, therefore, the integrity of a system is hugely dependent on the integrity of every single person who works within that system. And I go on to explain in paragraph 95 that the effect of prosecutorial decisions on people, on individuals, which is also what I mentioned in my opening remarks. The decision affects accused persons, their families, victims, witnesses, law enforcement agencies, and the public. I don't think I mentioned this part in my opening remark. The prosecutor possesses the greatest power to take away the freedom of the person, and the discretionary power exercised by the prosecutor in initiation, accusation, and discontinuance of a prosecution gives him, I should say, or her, more control over an individual's liberty and reputation than any other public official. So this is really what the impact of prosecutors' decisions are on people. I think I'll skip over the quotations.
Yeah, leave the quotations and let's get to 99, unless there was something else that you wanted to explain.
No, I just think
Let's go to 99, and I'd like you to look at the first sentence there where you're saying all members of the prosecuting authority, moreover, have a legal and ethical duty to promote truth and to refrain from conduct that impedes truth. What does that entail?
In a prosecutor's role is to ensure justice in our society. And I want to emphasize that in terms of a duty to promote the truth, it is not a prosecutor's function to seek a conviction at all costs. it is a prosecutor's function to help the court to come to a just decision and to seek the truth. And so the duty of truth, as I say in paragraph 99, it actually it derives from a prosecutor's constitutional obligation not to use false evidence or to suppress material evidence favorable to the accused. This duty of truth arises from various ethical structures and instruments that we have referred to earlier in my testimony, that require prosecutors to ensure and to have confidence in the truth of evidence before bringing or maintaining charges. And then I explain, go on to explain further that more than any other party in the criminal justice system, prosecutors, well, I suppose the police investigating officer would be, I should exclude actually. It should be the investigators and prosecutors have superior knowledge of the facts that are used to convict an accused or used during a trial. And therefore, they have the unique ability to present these facts to a court. I go on in paragraph 100 to say a prosecutor may impede the truth-finding process in several ways. For example, by misleading and misrepresenting facts, subverting the truth, or by making false statements or presenting false evidence.
Might I interpose, counsel, with regard to paragraph 95? That sentence before footnote 47. The prosecutor possesses the greatest power to take away the freedom of a person. I think that should immediately be qualified by what you state at 99. The prosecutor also preserves or protects the innocent. Am I right?
That is absolutely correct, Chairperson.
Just as your role, Advocate Mutlamunyadi, just as your role here, your task is to present all the facts favorable to
NPA or not.
The other way around.
Indeed, I agree. You dealt with what is contained in 100. You tie it with 101 because it is indeed the duty of a prosecutor to assist the court to ascertain the truth, not so.
Yes, I agree.
And in 102, paragraph 102, you are saying, where prosecution is used for ulterior purposes, this breaches the principle of legality. Can you expand a little bit about what that entails, the principle of legality?
Yes, certainly. I think firstly, before I go there, is that on the comment made by the chairperson about a prosecutor possessing the greatest power to take away the freedom of a person. As I had mentioned, Chairperson, that is the case, but the function of a prosecutor is to ensure a fair trial and to ensure that justice is actually seen to be done. So it's not a contradiction as such. It's explaining that in as much as we have this power to take away the freedom of a person, it's got to be exercised within the confines of our role of ensuring that truth and justice prevails at the end of the day. Chairperson.
I understand that as a lawyer, but somebody out there who's watching these proceedings will not understand what jurists and lawyers understand.
Sure.
When you put that statement in a public space, as you do, they will think that that is just your task to make sure or to take away that freedom, the enshrined freedom in the Constitution. So as you qualify that in paragraph 99, I just wanted to make sure that that paragraph 95 should be read, understood, in line with what you say, correctly so, in paragraph 99.
Understood, Chairperson.
Remember, we are not talking to ourselves here.
Mm.
We are talking to the nation and people who may not necessarily understand the legalese and the complexities of the space in which you operate.
Understood, thank you. So getting back to, sorry, Council, what was the, yes,
The principle of legality.
Yes, the paragraph.
Paragraph 102 on page 42.
Yes, so if prosecutors have a power that is given to them in terms of the Constitution and in terms of the NPA Act. And in the event that this power is not used for the purposes that it was intended, then it would indeed breach the principle of legality. So it emphasizes the fact that these powers that we have must be used for the purpose that it has been, for the purpose as set out in the Constitution and NPA Act.
Let's now move over to paragraph 103, where you deal with an accused rights in terms of section 35(3), the right to a fair trial, where you say the fundamental purpose of the right to a fair trial, as already decided in one judgment in the Constitutional Court, is to ensure adequately that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and possibly other interests of the accused. Now, in practice, such possibilities exist. If any, explain them. Possibilities that innocent people may be sentenced to jail.
So let me say that if a prosecutor acts with ulterior purposes, it's possible that innocent people may be sent to jail. There have been one or two cases where people that have been convicted have later on, years later, perhaps because of new evidence that emerges, it's been found that perhaps they were wrongly convicted. But those are extremely rare instances. I know of less than a handful of those cases, but every single case where an innocent person is convicted is a case too many. It should never happen. And so as prosecutors, we need to ensure that when we do bring cases, it must be done as I state in paragraph 103, always in an even-handed, open manner, honest manner, always recognizing the right of an accused to a fair trial. As prosecutors, we should hold that right to a fair trial as sacrosanct, whatever it means. But in particular, the rights of the accused must be protected, but equally, and I hasten to add, because it's often in the context of a fair trial, one forgets or perhaps relegates the rights of victims to a fair trial to further down the ladder. And so one needs to recognize the rights of all those, the accused, the victim, to ensure that there is a fair trial. And as prosecutors, we are required to, if we have evidence favorable to an accused, we are required to present it to a court so that we don't have any adverse effects as a result, or the potential of a person wrongly convicted So these are very, very important principles of a fair trial.
Thank you, Advocate Patohi. We can now move over to paragraph F or section F of your affidavit, where you deal with the independence of the NPA on page 43, the impartiality of its officials and the implications of these imperatives for the administration of justice. Now, in the majority of this, dealing with this topic of independence of the NPA, the prosecutorial independence and the independence of prosecutors permeates almost all the paragraphs contained in this
Is correct.
section. Now, let's take 104 and read it with 105. Explain what you refer to as functional independence.
In terms of the Constitution and the NPA Act, the functional independence, which I will explain, and the impartiality of members of the NPA in terms of carrying out their duties are provided for. And the functional independence refers or relates to the NPA's ability to conduct its work without any form of interference, hindrance, obstruction. And so if there's any kind of hindrance, obstruction, etc., that will be impeding on the NPA's functional independence in its ability to perform its functions independently. And the Code of Conduct, well, 105 deals with the UN guidelines on the role of prosecutors, but these are incorporated into the Code of Conduct, which is dealt with, of the NPA, which is dealt with in paragraph 106, which again talks to the independent exercise of the functions and powers in accordance with the prosecution policy directives, and be free from political, public, and judicial interference. Paragraph C of the Code of Conduct further deals with the issue of prosecutors performing their duties without fear, favor, or prejudice, and carrying out their functions impartially. And it sets out various requirements which fleshes out what this impartiality entails. And for present purposes, I will deal with some aspects of that. It provides that, well, item C of the Code of Conduct, C, subparagraph C, provides that prosecutors in acting impartially should take into consideration the public interest as distinct from media or partisan interests and concerns, however vociferously these may be presented. Item C sub F stipulates that prosecutors must act with objectivity and pay due attention to the constitutional right to equality. Item C sub G provides that prosecutors must take into account all relevant circumstances of a case at hand and ensure that reasonable inquiries are made about evidence, irrespective of whether these inquiries are to the advantage or disadvantage of the alleged offender. And sub H stipulates that prosecutors must be sensitive to the needs of victims and do justice between the victim, the accused, and the community according to the law and the dictates of fairness. And sub I provides that prosecutors, as we mentioned earlier, the Code of Conduct states, must assist the court to arrive at a just verdict and, in the event of conviction, an appropriate sentence based on the evidence presented.
May I take you a little backwards to paragraph 104, where you mentions that?
I just for clarity, for anybody who is listening, that we are all lawyers, prosecutors, and the Act are advocates, some are attorneys, they are lawyers. But in terms of the law, they are public servants. Am I correct?
You are, Madam Chair, you are correct.
But they are disciplined in terms of the MMS, or they are guided by the principles of public service.
It is correct, Madam Chair, because even the President has indicated in the terms of reference that we should we should have regard to the provisions of the SME.
It may be important, therefore, for anybody who does not understand this dichotomy to clearly emphasize this independence. Because when you are a public servant, it means you fall within the head of a particular department, which in this case is the Ministry for Justice and Constitutional Development. But that does not necessarily mean that in the execution of your duties as the public servant, you can be given instructions by the executive. Not a matter that should be made clearer out there in the public space. For those people who understand that prosecutors are public servants, they can be told by anybody in the executive position what to do or what not to do. The answer may not be for now, Council. I don't want to take you by surprise, but I thought that some of these aspects, for the people who don't understand, may need to be clarified by the Advocate Batoyi, yes, as she testifies.
I'm inclined to hasten to ask her at this particular moment, while she's explaining the independence of a prosecutor and the independence of the prosecutorial independence and the independence of the NPA, she can then explain that independence of a prosecutor vis-a-vis the prosecutor's responsibility towards the Minister of Justice. But that is contained I'm advised by my junior here that it is actually contained in section 112, paragraph 112, I beg your pardon. Advocate Batohi, in the Act, the reporting duties, you are reporting duties as an NDPP to the minister is contained here, apart from your accountability to Parliament. Section 33 deals with the minister's final responsibility over prosecuting authority. We would request you to start dealing with this. Start with the minister's final, section 33, where it deals with the minister's final responsibility over prosecuting authority. And the prosecutor's responsibility towards the minister, and whether the minister can give direction, prosecutorial directions to the NPA or its prosecutors. Has that perhaps been properly articulated? Did I articulate it properly for you to be able to?
Yes, thank you. I follow.
Thank you.
Which paragraph in the affidavit are you directing her to?
To paragraph 112. Yes.
Thank you, Council.
You may proceed.
Thank you very
Advocate
much. Thank
Batohi.
you, Chairperson. Chairperson, if I may, before we go to my affidavit, we go to Section 33 of the NPA Act, which sets out the minister's final responsibility over the prosecuting authority. Chairperson, the NPA Act, Section 33 states, and should I read out Section 33, given that it deals with the minister's final responsibility, and then I can answer in that context?
Yeah,
If I may, Chairperson, Council.
Please read Section 33, the whole of it, into the record. I think that will enable you to. Section 33, 1 and 2.
Yes, so Section 33(1) states the minister shall, for purposes of Section 179 of the Constitution, this Act or any other law concerning the prosecuting authority, exercise final responsibility over the prosecuting authority in accordance with the provisions of this Act. To enable the, subsection 2, to enable the minister to exercise his or her final responsibility over the prosecuting authority, as contemplated in Section 179 of the Constitution, the National Director shall, at the request of the Minister, A, furnish the Minister with information or a report with regard to any case, matter, or subject dealt with by the National Director or Director in the exercise of their powers, the carrying out of their duties, and the performance of their functions. B, provide the Minister with reasons for any decision taken by a Director in the exercise of his or her powers, the carrying out of his or her duties, or the performance of his or her functions. C, furnish the Minister with information with regard to the prosecution policy referred to in Section 21A. D, furnish the Minister with information with regard to policy directives referred to in Section 21(1)(b). E, submit reports contemplated in Section 34 to the Minister. And F, arrange meetings between the Minister and members of the prosecuting authority. So the matter of the Minister's final responsibility over the NPA has been the subject of much discussion, and it was also dealt with in the Zondo Commission. And in terms of, in line with what Section 33 states, and to answer your question, Chairperson, yes, it is important that it is understood what the minister's final responsibility means in the context of the independent mandate of the NPA as set out in the Constitution and in the Act. It is certainly not akin to the National Prosecuting Authority is a constitutional entity that resides within the Department of Justice, but it is a constitutional entity, unlike the rest of the department over which the minister may direct, manage, or control. I don't want to use incorrect words, but as you had indicated, Chairperson, the minister can inform or tell people within the department what needs to be done. But with regard to the NPA, because of its independent constitutional mandate, the minister's final responsibility is set out, is limited to what is set out in paragraph 33. And in as much as the minister can ask for example, a report with regard to any case, can ask for information about the reasons for a decision that has been taken, the minister cannot tell or dictate to the prosecuting authority what prosecutorial decisions need to be taken. And that is the difference between the minister's oversight or the role of the minister insofar as his or her final responsibility is concerned, vis-a-vis the role of a minister, vis-a-vis in respect of the department. So the act, and I deal with it in, if council can guide me, you referred me to a particular paragraph.
Paragraph 112, Advocate Patohi,
112.
on page 46. And whilst you are doing that, allude also to the fact that prosecutors, including DPPs, are public servants and are subject to the SMMS.
I do need to clarify that. Actually, I'm glad you raised that and reminded me of it.
Yes.
Yes, prosecutors, we are all public servants. We serve the public. But I want to emphasize that the members of the prosecuting authority are appointed in terms of the National Prosecuting Authority Act, and they are not appointed in terms of the Public Service Act. So there is a distinction to be drawn in terms of the applicability of certain instruments in respect of public servants appointed in terms of the PSA, the Public Service Act, and the National Prosecuting Authority Act. So there is a distinction. I don't have all of it, but it's important to understand that the Public Service Act, the NPA Act NPA staff appointed in terms of the NPA Act.
And Advocate Patohi, pardon me to intercept you. As the NDPP and an ADPP, a Section 6 DPP, are you subjected to the same disciplinary processes in the same way as an ordinary public servant would be subjected to? In the event it occurs.
The presidential appointments in the NPA are not subject. They are subject to this process. That is a president's process to deal with, to address issues relating to presidential appointments. With regard to the non-presidential appointments, the disciplinary processes are guided by the public service disciplinary processes.
Structure of the NDP and the ordinary non-presidential appointments.
Yes, in the NPA.
Thank you. Sit.
So the you referred me to paragraph 112. The two principles borne out by the legislative framework. Chairperson, I should inform the inquiry that 112 also refers to the Mohoro inquiry. So I think I'm in your hands, Chairperson. It does deal with two fundamental principles. But we could move on to other paragraphs.
You don't necessarily have to deal with what Mohoro has dealt with. Mohoro inquiry has dealt with.
Sure. So,
and in any event, I think it's just a regurgitation of those principles on autonomy.
That is correct.
Yes.
It is, Chairperson. Perhaps I can highlight, Chairperson, that the importance of independence of a prosecutor being jealously guarded by prosecutors. As I mentioned earlier, we should withstand, the possibility that various sectors, whether it's from the executive, whether it's from the business sector, whether it's civil society, whether it's the media, there can be all amounts of pressure from external actors on a prosecuting authority. And as the NPA, we need to make sure that we are not in our independence demands that we are not influenced by any of those factors, that the only thing that guides and determines our decisions are the evidence in a docket, the prosecution policy and directives, and that we act in terms of the code of conduct. So this is really highlighted. And as I mentioned earlier, an obstruction to the work of the NPA is in fact proscribed by the NPA Act. I think it's section 41 that makes it an offense to interfere in the work of the NPA. And that the fact that it is an offense to interfere in the work of the NPA demonstrates the importance of the constitutional guarantee of independence to ensure that the NPA is functionally independent, is able to do its work without undue influence from any sector. Chairperson.
Before you proceed any further, whilst you are on the on offenses and penalties, does it happen in practice that in your practice as a prosecutor or as a National Director of Public Prosecutions, that you come across hindrances that can impede your work? Hindrances or interference?
Yes, I understand the question. Let me say that prosecuting in South Africa at this time is a very complicated and challenging job. We have to do our job. We have to ensure that our constitutional obligations are that we comply. But the fact that people want to try to influence the work of the NPA, it happens, and it can come from various sources. But we have to, for example, even in the media, there's reports. There's, sometimes you've had, and I must hasten to add that this must not be seen. The media is an important stakeholder, and the investigative journalists have done incredible work. But sometimes the pressure or what emerges in the media, I have thought could amount to an obstruction of justice, where, for example, statements come into the hands of journalists, and these are published, and detailed analysis of cases, etc., to the point where I have thought that this could amount to an obstruction in the work of the NPA. But it's, as I said, the media is an important stakeholder and it has an important job to do, and they've done incredible work in investigative journalism. But I think we all need to be responsible, in terms of how we conduct our functions, in terms of strengthening the rule of law and not weakening it.
Might I interpose, Counsel? Sometimes less said, much better.
I agree, Chairperson.
Counsel, this is a delicate space where we may say things which we don't want or are not intended to be said. What Counsel Advocate Batoyi is saying about the alleged interferences or influences by certain institutions. So I suggest that you don't go there. Let's not go there. Does not bear much relevance, or any, at least for the purpose of this case. Unless, of course, I'm wrong. But what I'm saying, sometimes less said, much better. Let's focus on what is relevant, because we may emerge out of here having stepped on the toes of other people unintentionally.
I take it.
Chairperson, if I may, I thank you for that. I do want to say, though, that there will be allegations of interference in these matters and improper influence. And so it is important for the context of this case. Evidence will be, at a later stage, led in that regard.
By the media?
No, Chairperson, by the evidence leader.
No. You were mentioning
Oh, yes.
instances of influences and interferences, and you use the media
As an example,
example.
Chairperson. That is correct. I'm
And
not
that's
referring
why
to.
I'm saying to you, less said, much better. If it is not relevant for this case, let's not get there.
Certainly, as far as the media is concerned, it's not relevant for these purposes. Thank you, Chairperson.
Let us rather proceed, Advocate Batohi, to the next issue. Go to page 48, paragraph 116. Are you there? You deal with the status and role of prosecutors as contained in the Criminal Justice Handbook series. You don't have to go into any detail about that, but I need to refer you to what is quoted there regarding functional prosecutorial independence. And it says, prosecutorial independence refers to individuals as well as institutions. And one such institution is the NPA. Is that correct?
That's correct.
I think up to this stage, you have dealt more than enough with, you gave an extensive explanation about prosecutorial independence. Let's move forward. Because all these paragraphs, most of them contain, we're dealing with prosecutorial independence up to paragraph 126.
Yes, and it's set out in the Code of Conduct.
It's set out fully in the Code of Conduct.
That is correct.
This then brings us to page 54, where the Nkabinde Enquiry is dealt with. I would suggest that we leave that. Paragraphs 128, 129.
I might just say for people, everyone to understand that basically these paragraphs tend to deal, subject to correction of course, seem to deal with the very autonomy that we've been talking about.
That is so.
the substance of those paragraphs.
Yes.
Am I right, Counsel?
That is correct, Chairperson. And if I may emphasize paragraph 124, where the Constitutional Court has emphasized the importance of the NPA in the administration of justice, and then again referring to the constitutional guarantee of independence of the prosecuting authority, requiring that we, of course, exercise our functions without fear, favor, or prejudice. But the court goes on to say that the reason for this is not difficult to explain. With a malleable, corrupt, or dysfunctional prosecuting authority, many criminals, especially those holding positions of influence, will rarely, if ever, answer for their criminal deeds. Thank you, Chairperson.
Let's then move over to page 58, where you deal with reasons for referring a complaint regarding Advocate Chauke to the President within the purview of Section 12.6, read with Section 14.3 of the NPA Act. Maybe as a start, remind everyone else as to when you are appointed National Director of Public Prosecutions.
I was appointed I took office. My appointment was announced in December. I took office from the 1st of February, 2019.
And you deal with that in paragraph 135 of your affidavit.
That is correct. I should perhaps, for purpose of the record, I may have mentioned that I also served as a DPP in KwaZulu-Natal from 2002 to 2009. That was for about 7 years before I went to The Hague, to the International Criminal Court, and then returned in 2019 to take up the current position.
Beg your pardon, 2002 to 2009.
That is correct. The DPP of KwaZulu-Natal.
CPP KZN.
That's correct, Chairperson.
As a prosecutor, as a director?
As the DPP, as the Director of Public Prosecutions.
As a DPP.
Yeah, the same position that Advocate Chauke currently holds.
Did you also prosecute in the lower courts prior to that?
Yes, I started prosecuting in 1986 and prosecuted in the lower courts, dealing with the least serious offenses, and then proceeded to the High Court in 1992 in Durban, where I prosecuted in the High Court from dealing with murder cases, rapes, robberies, the serious cases that are dealt with in high courts, and then was appointed a deputy DPP in, I think it was 1997. And then prior to that, Chairperson, for the purpose of record perhaps, I was appointed a leader of evidence in the, well, not lead of evidence. I was appointed as one of 2 prosecutors in the unit that was set up by President Mandela to investigate atrocities committed during the apartheid era in 95 to 97. I was involved in that. Became a deputy DPP in 1998. Became the head of Scorpions, the Directorate of Special Operations in, I think it was around 1999. I must check these dates, and then became the Director of Public Prosecutions in KwaZulu-Natal in 2000 until 2009, when I left to The Hague and then returned in 2019. Thank you, Chairperson.
Counsel, all of us profiles are in the public space. I know that her profile may be in a public space. Is it not possible to get her CV and present it to us?
That may be possible.
With all the milestones that she has achieved. May we have copies of her profile?
I will arrange for that, Madam Chair.
Will it be possible, Madam?
Yes, certainly, Chairperson.
Yes,
Thank you.
But when you look at paragraph 133, my sister was just bringing it to my attention, the first few introductory words. You were a prosecutor since December 1985.
That is correct, Chairperson.
In KZN.
That is correct.
I beg your pardon, I'm being told that I'm doing the wrong thing here. The introductory word to paragraph 133, you were a prosecutor since December 1985 as a prosecutor.
That is correct, Chairperson.
In KZN.
That is so.
Thank you. I beg your pardon, gentlemen.
Madam Chair, may I at this stage ask as to what time are we expected to adjourn for lunch recess? It's almost 1:30.
So that because we had breakfast late, we could adjourn at 2:00.
That's in order.
Unless, of course, if someone would like to go to the clinic, you can let me know. For a clinic, we can take a 5 minutes break.
To stretch our legs as well.
Yes.
May we take a 5-minute break?
Yes, sir. Yes, thank you, Advocate Mutlamunyane. We'll take a very short break. Good afternoon, Advocate Batoi. I'm sorry we got delayed a bit. There were some technical challenges that we're resolving with the IT people. Hence, we started a little bit late and knew the media. We begin, Council.
Thank you, Madam Chair. Advocate Patohi, when you adjourned, you were dealing with paragraph 133, and you also give a short resume of yourself, and at the later stage, it will be made available in whatever form to the panel and to everybody else. Now, let's begin by going to paragraph 135. Which will lead us to your reasons for referring the matter to the office of the President.
Proceed.
Proceed.
The paragraph.
We're on paragraph 135. Page 58, Advocate Patohi.
I'm there.
When you arrived, when you took up office, let me rephrase. You discovered that there were certain matters, serious matters, that were affecting not only the integrity of the NPA, but also its functioning, how it functioned. Can you elaborate on that?
Yes, thank you, Council. Upon taking office, well, even before I took office, there had been for a number of years prior to that allegations and much in the public space about allegations of capture of the NPA in the context of state capture. When I took office, I discovered that there was this credibility of the NPA had been seriously dented because of these allegations. There were serious allegations against members of the leadership of the NPA, including my predecessor, Advocate Abrams, Advocate Jiba, Advocate Murebi, who served as National Director, Acting National Director, Deputy National Director, and Special Director of Public Prosecutions. That would apply to Advocate Murebi in the NPA. And as a result of these allegations, the President had instituted an inquiry into the fitness to hold office of Advocates Jiba and Murebi, which was headed by Justice Mohoro. In fact, when I took office in February of 2019, the Mohoro inquiry had sat but had not rendered its report. Its report was rendered on the 1st of April in 2019. The allegations against Advocate Jiba related to, and I should first, before I say anything further, Chairperson, I should say that I found this when I came to the NPA. I was not in the NPA at the time. I don't have personal knowledge of this. I think I do mention it later in my affidavit. But I have, what I will testify about are issues that I have gleaned from evidence and from other material that I've had access to.
Like you said in your opening address, when you were asked by counsel that some of the facts pertaining to this matter, you do not necessarily have personal knowledge thereof.
That is correct, Chairperson. So there were many allegations, and they included the matter of Major General Johan Boysen, who was the former head of the Directorate for Priority Crimes Investigation, known as the DPCI, or colloquially referred to as the Hawks, in KwaZulu-Natal. And that those allegations will also are the subject of this current inquiry. So the allegations against Advocate Chauke in respect of the Boysen matter relate in large measure to the same issues that were in the Mahoro, that the Mahoro inquiry was looking into. The allegations against Advocate Mwebi in the Mahoro inquiry related to his decision to withdraw charges against Lieutenant General Richard Mdluli, who was the head or the former head of crime intelligence. This present inquiry also relates to a decision to withdraw charges against Mdluli, I will refer to as Mdluli. However, the decision taken by Advocate Chauke to withdraw the criminal charges against Mdluli relate to different charges. The ones taken by Advocate Mwebi related to fraud and other related charges. This one relates to murder and other charges that I will deal with later. The Mahoro inquiry concluded that in view of the totality of evidence, I paraphrase phrase, Jiba and Mwebi were found not fit and proper to hold respective offices. Separately, at the time when I took office, the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, known as the State Capture Commission or the Zondo Commission, which was established on the 9th of February 2018, and chaired by the then Deputy Chief Justice Raymond Zondo, had been inquiring into allegations. Part of the inquiry of the Zondo Commission, part of the investigations at the time, I'm aware, also related to allegations against various NPA officials and their involvement in the prosecution of Boysen, and also with regard to the withdrawal of the charges against Mdluli. We are on paragraph 140. Should I continue?
Continue, Advocate Batohi.
So from paragraph 140, Chairperson, the essence of the case against, the essence of the Boysen matter is set out. As I say, it's what I've gleaned from evidence and other material. In early 2020, Advocate Jiba, in her capacity as acting national director.
I beg your pardon? You must have misread it. It's 2012.
I beg your pardon. Thank you, Counsel. In early 2012, in her capacity as acting national director, Jiba decided to set up a team of prosecutors from Gauteng and Northwest to conduct the prosecution of police officials in KwaZulu-Natal. These police officials were in the main from the Serious and Violent Crimes Unit in KZN, and I will refer to them as sometimes perhaps the SVC unit. Advocate Chauke was the DPP of South Gauteng at the time.
Did I interrupt you, Advocate Batohi, Advocate Mhlamoyane? I'll still go back to that point of dealing with these bundles behind us. You've just referred to the Mahoro Commission of Inquiry. I know that we have bundles that we received, or the inquiry received from the NPA. And of the bundles, the Mahoro bundles constitute these two bundles. And as we agreed yesterday, we should be in a position to mark these bundles. Remember, when you finish, we must send the entire record to the president. And it must be properly bundled, collated, and paginated. May we, and please remind me, I shouldn't be reminding you again and again. May we refer to this bundle as identified in the index. I think it is called MC. MC, we should be Mokoro Commission,
That is correct.
and you'll
Chair.
call it MC1 and MC2. MC1 is from page 1 to page 00556. I beg your pardon, it's MC1 from page 1 to 275, and then MC2 will be from 276 to 556. If you like, you can refer to it as exhibit, as you did with the former exhibit MC 2, and the first one, exhibit MC 1. Yes, thank you, Council. I should remind you of that when you touch on the evidence in respect of which bundles have been filed of record. Please remember, your junior counsel and senior counsel will also remember that, to remind you or to remind us so that we can do the right thing. May I proceed, sir?
Thank you, Madam Chair. Advocate Patohi, we are on paragraph 141.
Yes, that's correct. 142. Sorry, 142.
You got to 142, yes?
That's correct.
Yes.
If I may proceed.
Yes, you may proceed.
So Advocate Chauke was the DPP of South Gauteng at the time. And for all intents and purposes, he was appointed as the leader of the prosecution team and unlawfully acted as the de facto DPP in this regard, as his conduct will demonstrate. The allegations against Advocate Chauke, in essence, relate to the manner in which he and other prosecutors dealt with the prosecution of Boyson and other members of the Serious and Violent Crimes Unit. And
I'm sorry, again, I just want us to do things right, because the heading on page 59 in bold letters is the Boyson's matter. That will then require us to mark the bundles referring to this aspect of the case. And we have about 11 bundles in respect of
The Boyson matter.
the Boyson's matter. I will ask my clerk to come over to help me. We have 11 bundles in respect of the Boyson's matter. I beg I
My
see you
apologies.
confer with the jury. No, that's okay. You can take instructions or confer with your colleague.
Thank you, Madam Chair. Thank you, Madam Chair, for the opportunity.
Able to resolve something with your junior?
Yes, we're able to resolve something because very soon I was going to refer Advocate Patohi to a bundle which is not which is not the Mokoro Commission bundle.
You're now dealing with the Boyson's bundle.
Yes, but earlier on, we referred to the Mokoro Commission bundle, and there's also a Boyson bundle, which you say it's about 11, you're having about 11 volumes. But then in the course of her evidence, I was going in a moment to refer her to legal opinions bundle, to a page in the legal opinions bundle. And I was finding out from her as to whether is it not an opportune moment before I refer Advocate Patohi to that bundle to then have it appropriately marked.
You will mark it when you come to it.
I'm comfortable with that.
You see, now we are at Boyson's matter at page 59, starting at page 60, that heading. So let's do it sequentially like that, so that we don't confuse. When you reach the legal opinions bundle, it's written LO numbers.
Indeed.
We will name it. Just remember that. So we are now at the Boyson's matter, 11 bundles. We will name them B1 to the last number. B1 to B11. And I'm sure the team for Advocate Chauke will remember the naming of these bundles, because apparently there's still going to be more bundles coming. Otherwise, we will all be confused here with the documents that we have been referred to. Will that make it easier for all of us to follow? In accordance with the index.
Thank you, Judge. It should be fine. I should note, though, that on the electronic version, we only have 8 and not 11 volumes from the Boyson's matter.
That may be the case, but you can just confer with a clerk about the completeness of your volumes.
Thank you, Judge.
Thank you. It might just have happened with the binding, I don't know, but do check with our clerks.
Will do so. Thank you, Judge.
Yes, thank you. We have marked the bundles accordingly.
And what about the pages?
The pages are in the bundle themselves. They are marked B number 00100 something. It is just the labeling, as we spoke yesterday, that we're given the bundles names to identify them. The contents are properly indexed in the document. That is page 1, page blah, 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 up to the end of the volume.
Yeah, we will later find out as to which one is B1
Yeah.
and which one is B2.
Yes. Well, those are your documents. So we got them from the NPA. So we just did what we did to make our work easier. You may proceed.
Thank you, Madam Chair. Let's go back, Advocate Batohi. Quickly tie 142 and 143. You were explaining that Boysen was a member of the Serious and Violent Crimes Unit. May you proceed?
Yes, so the allegations against Advocate Chauke relate in essence to the manner in which he and other prosecutors dealt with this Boysen prosecution. Well, the prosecution, I'm referring to it as the Boysen prosecution, but it's prosecution of Boysen and other members of the Serious and Violent Crimes Unit, and their conduct in this process leading up to the two separate applications that were brought in the High Court relating to these racketeering certificates. And I'll deal with these applications in a moment. I will deal with now with the essence of Advocate Chauke's conduct. On 17 August 2012, Advocate Jiba issued two racketeering certificates for prosecution of Boysen and members of the Serious and Violent Crimes Unit. Before I proceed any further, Chairperson, maybe I should explain that racketeering charges are brought in terms of the Prevention of Organized Crime Act. And in terms of the Act, it is the National Director that must authorize prosecutions in respect of racketeering charges. So Jiba would have issued these certificates in her capacity as the acting National Director at the time. And these certificates related to contraventions of Section 21E and 21F of the Prevention of Organized Crime Act 121 of 1998, which is referred to as POCA, P-O-C-A. Chairperson, after these certificates were issued to proceed by the acting National Director to proceed on these racketeering charges, Boysen instituted an application to review these charges and have them set aside, to review and set aside the racketeering certificates that were issued by the acting National Director. My understanding is that this was in early 2013, but we can easily verify that. Boysen alleged in his review application that after the receipt of the indictment, he requested Jiba to make available all the documents on which the state intended to rely. In compliance, as a result of this, 23 dockets were made available to him. And
So
I should...
To interpose, is it deliberate that Advocate Jiba is referred to as Jiba while, for example, Advocate Chauke is referred as Advocate Chauke, or is it a typo? Or
Chairperson, we refer to Advocate Chauke everywhere as advocate, and everyone else is referred to by just the surname.
what, just the
We
same?
can, yes,
So
that's
it's,
correct.
it's a common.
It's everyone else is just the surname, but Advocate Chauke, who's the subject of this inquiry, who's referred to as Advocate Chauke throughout.
Thank you.
But we are happy to, of course, refer to her as Advocate Chiva.
No, I just wanted to understand
Thank you.
the why behind. Thank you.
Thank you. So if I may continue, Chairperson, after Boyson requested the documents on which the state intended to rely in the prosecution of the racketeering charges against him, he received 23 dockets. According to Boyson, he said that he is mentioned in only 2 of these 23 dockets. In one of the 2 dockets, he's mentioned in the statements of 2 witnesses. Both these witnesses stated that he arrived on the scene of a shooting in a helicopter after the event. Perhaps I should also clarify for the committee. Chairperson, in all of these cases, the deceased persons were suspects in various investigations, and the details of this evidence will be provided by other witnesses. But just to give the committee a context of these charges. So Boyson mentioned that in the one docket, the 2 witnesses stated he arrived on the scene after the shooting. And in the second docket, the witness states that also he noticed Boyson on the scene after the incident had taken place, the shooting had taken place.
Sorry, madam. I suppose we have not been able to peruse through the 11 bundles sufficiently. We carefully gone through them. I don't remember seeing some of the statements, and perhaps if you are aware, or if council is aware that the 2 statements that you are referring to, that Mr. Boyson's refers to of the 23 are in the bundles.
Chairperson, I
Council?
can't confirm, but perhaps council can.
Madam Chair, may I take this opportunity to refer you to documents that we referred to earlier yesterday, the SB1, which constituted they are part of her affidavit, actually. They are annexures to her affidavit. Indeed, yes. And, yes, yes. On page 088 of your bundle, there's a statement marked SB1B088.
That's what we dealt with yesterday.
Yes, that statement makes reference to what she's testifying about.
That would be helpful if you can refer to that, because we are now doing the facial metrics.
Yes.
I beg your pardon. It will be helpful as she testifies and she's speaking to this document, that you go to those documents, counsel, and otherwise they are going to be hanging. We wouldn't remember why they are here. It will make our task more difficult. So as she is testifying, referring to each of those annexures, do take us there. Even if you don't deal specifically with the contents, but at least we should be able to note the relevance of the availability in this record.
Yes, but may I confirm a bit? This one here is the same. This one. What's the difference? Yeah. Thank you, Madam Chair. Before we proceed any further, may I indicate to the panel that the statement contained in Annexure SB1B marked as NJ2, which is on page 088 of attached to her affidavit. It's a similar, in fact, the same statement that is contained in SB1D and is marked, it's Ayer statement, one Colonel Ayer, Rajendran Ayer. These statements were made on the same day, the 3rd of August 2012, and the signature of the first one appears on page 090, SB1B 090. Now, the other one is NJ4, which appears on page 097, SB1D 097.
I thought you go to NJ3 in that sequence of the amicus.
No, I did not want to. What I want to explain for the moment, yes, to the two, that they're statement of one person.
Pardon, yes.
NJ4, yes.
SB1B
097 up to SB1D 102. The one was signed on the 31st of August 2012. That is the one that ends on page 102. And the first one with a different font, but they were deposed to by the same Colonel Ayer. SB1B 088 has been signed on the 3rd of August 2012. That is what I wanted to bring to your attention, that they refer to one and the same person.
This is helpful, Council.
Indeed. Thank you, Madam Chair.
You may proceed.
As and when you proceed, Advocate Batohi, and you are referring to statements, put yourself together, put your mind to the fact that these statements are available, and refer to them, which are marked NJ2, NJ3, NJ4, and 5, which are SB1 in your bundle.
We have marked them as you did yesterday accordingly as NJ2, which is SB1B 088. The next one is NJ4, SB1D 097.
Yes. Are you in a position to proceed on that basis? That reference should be made to the statements.
Yes, I am. If you just allow me to gather my thoughts, because the statements that we are referring to now, Chairperson, I have not identified which one in my statements relates to. For example, I say both witnesses state that he arrived at the scene of a shooting after the event. Now, I need that to correspond to one of those statements, and I can't give you that answer at the moment. So I'm not sure if we need to take an adjournment or whether I can proceed, Chairperson, and if that's going to hamper moving forward.
Yes, my recollection upon the reading of the bolded statement, I think one of those statements refers to that, but subject to correction by your counsel. If not, you can reflect, and before you step from that stand, you can then refer to that so that we can correct this part of the record. For now, we will speak of the two statements.
Thank you, Chairperson. I will proceed on that basis.
You may proceed.
Your junior can check so long to help Advocate Batoi whether the two statements or either of them do capture this aspect in relation to one of the witnesses having alleged that Mr. Boysons arrived at the scene in a helicopter. In other words, he was present at the scene. They will help you in that regard.
Thank you, Madam Chair. No, that's not what- Those statements are not in here. It's in the docket. That was what you were saying. It's not in these images. Madam Chair, I'm informed that may I request a
My
short adjournment to clarify these issues? Because I get confused as to
I can hardly
exactly.
hear you, counsel. Are you requesting
I'm requesting
another adjournment?
a short adjournment just to clarify
Short adjournment.
these issues of these documents here. Because I'm getting different messages.
Yes, counsel, we'll take a short adjournment. We'll wait, and then you call us when
Yes,
you're
ma'am.
ready. Good afternoon, everyone. Once again, we apologize. Let me speak Setswana a little bit. Hatrena itloga mo stationing. You know what it does. It moves very slowly. So when the train takes off from the station, it starts very slowly. And it picks up momentum in the middle of the journey. And that's where we are, that we encountering all these challenges because we are at the beginning of things. And we realize that we're grappling with getting our records in order. We adjourned to discuss these issues so that we can address them right at the outset. It is for that reason that we had to sit with counsel and all concerned to discuss the best way of proceeding from tomorrow with a properly collated and paginated record. We have agreed that to make things easier, the teams will have copies of what we have, but I must place it on record that the NPA provided to us with documents online, a link containing the documents that we have behind us. Advocate Mutlamuyani should be having the same documents in the link, and so should the team of Advocate Chauke be having the same documents. They have not printed those documents. That's why they don't have the records that we have. They should have made those copies. Therefore, we decided that we will adjourn and will facilitate the making of the copies because the ministry has provided us with tools, printers, paper, and everything in the building. And therefore, this afternoon, our PAs, our clerks, in collaboration with them, will seize the moment and make copies for themselves that are in line with the bundles that we have. And those documents will be marked accordingly. Advocate Batoy, it was for that reason that we kept you waiting again, because it makes it difficult for you to go back and forth, being referred to documents that are not properly marked before you. So for that, we apologize. It's not the fault on our part. Every one of us is having what we have. We have been on it and made sure that we use the moment and copy the documents that the NPA provided to us. And so should the evidence leader and the Chauke team. We will adjourn so that you can do what we agreed upon in the chambers, and make sure that we have the document as collated and paginated, indexed, and named as we have done with our copies. We'll adjourn until tomorrow morning. We'll adjourn until tomorrow morning at 9 o'clock. We start at 9 tomorrow morning because we plan to adjourn at lunchtime until next week, Monday. So let's start early tomorrow, 9 o'clock. And I hope by tomorrow you'll be having the documents that we have been talking about. Thank you very much. We adjourn.